It was no surprise this week when the Permanent Court of Arbitration in The Hague issued an award that strongly supported the Philippines' position regarding the hotly disputed conflicting claims in the South China Sea. It was also no surprise when China dismissed the award, which is based on the United Nations Convention of the Law of the Sea. China reiterated its longstanding position that the tribunal lacks jurisdiction and that other countries, particularly the U.S., were meddling in the region. These matters are sufficiently serious to warrant sophisticated understanding of China's position. What precisely does China reject? What are the legal foundations and implications? Why has China refused to participate? And how will China's rejection of the award affect its international image and its oft-stated intent to uphold the international order and strengthen the UN? Understanding China's legal position is critical to get closer to China. On Tuesday, July 12th, the Permanent Court of Arbitration in The Hague announced its decision regarding the South China Sea case, which had been initiated unilaterally by the former Philippines government based on provisions of the United Nations Convention of the Law of the Sea, the UNCLOS. In the award, the tribunal concluded there was no legal basis for China to claim historic rights to resources within the South China Sea areas falling within the 9-dash line, found that none of the maritime features, such as islands and reefs claimed by China, was capable of generating an exclusive economic zone, called China's actions in the South China Sea, such as constructing artificial islands, unlawful, stated that China's reclamations caused severe harm to the environment, and stated that China aggravated the dispute. The Chinese government was swift in its response. On the same day, the Chinese government issued a statement reaffirming China's territorial sovereignty and marine rights and interests in the South China Sea. Moreover, Chinese President Xi Jinping, during a meeting with European leaders in Beijing, reiterated China's position that the South China Sea islands have been China's territory since ancient times, and that China's territorial sovereignty and maritime interests in the South China Sea in any circumstances will not be affected by the award. President Xi stressed, China has always been a guardian of international rule of law and of fairness and justice, and will always adhere to the path of peaceful development. A day later, the Foreign Ministry of China issued a white paper on the arbitration ruling, asserting that the Philippines' territorial claim over part of the Nansha Islands is groundless from the perspective of either history or international law.
Chinese people will not accept the result, and all people around the world who uphold justice will not accept the result. China's non-acceptance and non-participation is to safeguard international rule of law and regional rules. Now the farce is over. It's time to get back to the right track. China has taken note of the signals from the Philippine government that is willing to resume discussion with China over the South China Sea issue.
While many Western countries and media accepted the tribunal award, other countries aligned with China's position.
I think the arbitration reflects the motivation of Western countries to curb China's rise as a global power. The tribunal has crossed the line to interfere in the dispute under the name of the law. It is true that many countries joined the UN Convention on the Law of the Sea, but it is also true that the Convention says disputes should be solved through dialogues. On the issue of contradiction and dispute settlements, Rwanda and China have the same position. That is what we always think. Disputes should be resolved through peaceful dialogue by both parties, not subject to external forces. So any external intervention will not bring good results.
Immediately after the issuance of the tribunal award, the UN released a statement on the Chinese microblogging platform Weibo, as well as on its official website, stating that its principal judicial organ, the International Court of Justice, had no involvement in the case. The Arbitral Tribunal, a temporary organ of the Permanent Court of Arbitration, is a tenant of the Peace Palace in The Hague, which also houses the independent UN International Court of Justice. I'm joined by one legal expert and one international security expert. Li Ju-Qian is professor of international law at China University of Political Science and Law, and Zhu Feng is professor and director of the China Center for Collaborative Studies on the South China Sea at Nanjing University. Welcome. Were you surprised by any aspect of the award, Professor Zhu?
No, I'm not. The reason is we also see some sort of the signs alluding, well, definitely in favor of the Philippines. Then I think the reason of this verdict, or in other words, it's a tribunal award, just some sort of, we say, clarification of what kind of the things just coming over, and in what way it is truly in favor of the Philippines. But I think the partiality is some sort of another very impressive one for Chinese, because it's too much in favor of Philippines and too much, we say, in favor of China.
Professor Li, did you, when you heard the award and you read it through, was it stronger for the Philippines than you expected?
I think, this award, I have the same feelings as Professor Zhu. This award is unfair, and also many of the key points is go too far.
Okay, I think what would be helpful to do is if we go through the key points of the award and try to understand Beijing's reaction to each of these points on a specific basis. And it's laid out in the full awards, like 500 pages, which I have not read, but we've read the summary, so we understand what they've said. So the first one begins to talk about what you're talking about, which is perhaps the most important, and that is the historical rights and the so-called 9-dash line, which defines what China believes to be its sovereignty in the South China Sea. And the ruling, as I read it, was that because China was a signature to the UN Convention of the Law of the Sea, that superseded any prior historical claims based on the definitions in that convention that everybody signed. I think that's what they claimed.
Partly you are right, but partly you are not. Okay. Because the UNCLOS, of course, is some sort of, with a maritime constitution. It's some sort of a very comprehensive embodiment of all the norms and the rules over the maritime issues. But the problem is, even UNCLOS also recognizes the historical entitlements, like the historical bay, historical water. But of course, there's no very clear relevance of some sort of historical rights. But the problem is, I also discussed with a couple of very well-distinguished international lawyers. So they just believe UNCLOS does not exclude historical right claim. But of course, majority of the international lawyers will believe after the conclusion of this UNCLOS, then the individual state should just recede from some sort of traditional right claims. But the problem is it remains a very disputable and a debatable question. Even just standing on the position of the minority, I don't think the UNCLOS is totally immune from some sort of, we say, such a justification of the traditional rights. So if given some sort of such an inherent controversy, then now the tribunal award is completely and is very recklessly and bluntly, we say, turned back to the China's historical right claim. I don't think it's reasonable and fair.
The second major category is called status of features, which is definitions of islands, reefs, shoals, and the claim is that what China has done in creating the artificial islands do not qualify for any of the economic or definitions because the islands were not in the definition, therefore don't qualify.
Yeah, I think that's also some sort of a weak, the part of the entire awards. Everybody knows, of course, most of the South China Sea we say the maritime features are some sort of small ones, rocks, reefs, showers. But never forget, there is a E2APA. E2APA is, in all the definition, is a real island. According to the definition of the UNCLOS, it could just have the survivor people with some sort of water, with the soil, and also vegetation there. Then we also know that Marinjo also incited the international visitors to testify how reliable and habitable the E2APA is. But the problem is that ironically, the tribunal totally just, we say, turn a left ear to some sort of such a testing and the testaments. They just trying to just, how say, inexclusively declare that all the maritime features China take over just belong to some sort of low tide elevator or some sort of maritime features without any international, entitlement for easy. But it's not true. It's also some sort of against some, we say, conventional Western in South China Sea. That kind of the category will keep this award on the file, very obviously.
Isn't it important to define these difficult issues? Shouldn't the international community come together and say what an island is? Shouldn't there be a mechanism that the entire international community agrees with? And at least at this point, through the UN Convention, which most countries except the US has not signed, this tribunal has now given those definitions. Isn't that a good thing? So we have an international standard, Professor Lee.
Actually, in the law, in the international law, there are actually two aspects. First is the international custom. Secondly is the convention itself, treaties. So the treaty itself is just regulate something all parties agree to it. Outside of those things is belong to international custom. So the international convention, the UN Convention on the Law of the Sea itself, do give some definitions for islands and some of the rocks, the reefs, but it's not give all the definitions to everything. And when we talk about the second point of the award, it's really relating to the first point, because they do not recognize the status of 9-line. Then they have to go back to the island itself, which means that they divided all the islands one by one. Then you will not get the whole picture of if these are a kind of, if the islands are archipelago or not. On the UN Convention on the Law of the Sea, there's some definitions on archipelago, including mentioned they are naturally as a group or historically as a group recognized as archipelago. So in South China Sea, for long history, it's recognized as archipelago, which also means that not only the island itself, but also include the waters between the islands, the features among the islands. So just to point the island itself one by one to get a conclusion is really go beyond the definition or the standard of the archipelago itself.
Welcome back. The third category of the award is called harm to marine environment. And the charge is that China has caused severe harm to the coral reef environment and violated its obligation to preserve and protect the fragile ecosystems. And then it goes on. What do you make of that, Professor Zhu?
I have to say it's a more disputable part of the award. I have to say yes, China's island reclamation is some sort of controversy. Then what kind of damage we have caused to the coral system in South China Sea? We needed some sort of a very convincing and conceivable evidence. But what's the award just the rule on this? The reason is they just cite or use the Philippine provided some sort of their evidence. But China also have a counter evidence. Then we say, yes, in the process of land reclamation, we take care of the coral protections. We also like to just the way say diminish some sort of such a very effective, very undermining effect. So the question is this: if the tribunal just partially or just take one side of the judge based on the Philippines provided some sort of evidence, it's also another, we say, unfair. It's also another unjustified, the treatment to Chinese. So that's why I consider that points always will cause a big controversy.
The claim is under the category of lawfulness of Chinese actions, a series of claims that what China has done vis-a-vis the Philippines in certain areas, Scarborough Shoal, has been in violation of the law.
Actually, no. China, the Chinese government mentioned many times that when China reconstruct some of the islands, it's just on Chinese territory. When we talk about the South China Sea, we mentioned the 4 different islands or archipelagos. So those archipelagos for a long period of time is regarded as China's territory. So China on its own territory do something including the building on the island itself, including make habitant on the island. That is lawful and permitted by the international law.
There are a number of points under this category of lawfulness of Chinese actions. The first one is interfering with Philippine fishing and petroleum exploration.
I think it's a very disputable issue. On the other hand, I see some sort of such a politicization of the verdict, or in other words, the tribunal judge is, let's say, inappropriately just engage themselves to such a political issues. How to define the China's disruption to the Philippines fishing activities? Back to the year 2012, then we will see Philippines use their gunship, use their warship, then intercepting the Chinese fishermen to do the activities in some sort of disputed waters. Of course, it's irritated the Chinese. Then we push it back and also use some sort of a Coast Guard ship and setting some sort of, we say, cordoning off area and get it both sides just how say take away from some sort of such a dispute. Of course, now the Philippines just push it very hard and say it's a Chinese disruption, it's Chinese interruption. But my interpretation is it's mutual. It's a very some sort of way say disputes driven, some sort of interactions. Of course, it goes very ruthlessly.
The final category, the fifth, is called aggravation of dispute, and I personally was surprised to read that in this type of a ruling, that the claim is that China's actions since the commencement of arbitration had aggravated the dispute because of what China has done. How do you react to that?
Of course, I consider it's a very stupidly biased argument. So then we will see the disputes just lingered for years, for decades. So then it's not just China to blame. Then Philippines, Vietnam, and other, we say, contenders or contending claimant state, they're also equally to blame, because there's no way China could just start up just unilaterally. Then we will see, for example, so there's some sort of disputed areas, water areas in South China Sea, but the numbers of the islands, reefs, rocks, and the Vietnamese occupied and the Filipinos occupied are more than what the China have at hand. So then we will see it's totally, we say, discrimination. It's some sort of, we say, in Chinese term, it's westernized some sort of such a judicial discrimination, because, as I say, so there's a lot of evidence just putting together that we will see Vietnamese, Filipinos prove to be the more proactive than the China. So then the irony is this reward just to keep the China to blame. We consider why such a since we're getting some sort of such a unstable. It's not a Chinese responsibility only. If the category 1 say some sort of aggravation of the tension, then he should put in all sides in. So then that's, I have to say, it's jokingly some sort of, we say, misplaced condemnation.
You're watching closer to China. China says its territorial rights over the South China Sea are rooted deeply in history. China's territory since ancient times is the common phrase. China references historical data showing that Chinese people began sailing the South China Sea as early as the Qin and Han dynasties, 2021 BC to 2000 AD. During the Sui and Tang dynasties, 581 to 907 AD, Chinese fishermen worked the South China Sea. Even today, fishery is one of the major industries in the South China Sea. It's a tradition passed down from generation to generation. Su Chengfeng is a veteran fisherman. The 80-year-old is building a model of the boat he rowed with his grandfather. When he was 13, they sailed to the Nansha Islands, also known as the Spratlys.
We went fishing in the South China Sea because we regard this area as our home waters, where ancestors sea. It's also because we hope to defend our territorial waters from encroachment by other countries.
The secret to their success is called Geng Lu Bu, which means the road book. There are numerous versions, the cumulative knowledge of centuries of hard-won experience. Every island and its surrounding features are clearly described. Chinese experts believe this is clear evidence to suggest that Chinese fishermen were the first explorers of the South China Sea.
With the increasing complexity of disputes in the South China Sea, many surrounding countries have intensified their actual control over the islands and reefs. Chinese fishermen have been harassed more often in traditional fishing areas. Some have been expelled or detained. It will be a big challenge to maintain normal fishing and exploration activities and protect the islands.
Collecting historical evidence of Chinese sovereignty over the islands and reefs in the South China Sea has been the focus of Professor Wu Shichun's work for 2 decades. The more he studies, the more he believes that, compared to the territorial claims of other countries, China has the best basis of its territorial claims.
The South China Sea, important to the Chinese people since ancient times, is our heritage to which our forefathers devoted their wisdom and even lives. The Chinese government remains unwavering in its resolve to safeguard China's territorial sovereignty and maritime rights and interests in the South China Sea.
Welcome back. Professor Lee, the court says that it does not deal with sovereignty because that's outside its jurisdiction. But yet, many of the points that they're making, China says, have implicitly the question of sovereignty as a fundamental aspect beneath it. Is that a strong argument?
Yes, if we go back to follow the court's their legal reasoning, if they do not do any award relating to the sovereignty, which means that China have its right to do anything within its sovereignty, which also means that the award itself will not prevent China to protect herself on the islands, on the sovereignty there. And the court itself, the judgment, especially relating to the 9-dash line, they go beyond of their authorizations, which is go outside of the UN Convention on the Law of the Sea. So if the court follow their own line, of course, the award itself has nothing relating to the territory or the sovereignty, which also means that China keep its sovereignty and international interest according to the international law.
Professor Zhu, do you see sovereignty as fundamental to the entire ruling?
Of course, I think the real essence of the ruling is about the sovereignty. It's very simple. For example, the ruling on some sort of, we say, lack of evidence in with the uncross on the China's U-shaped line, we say, 9-dash line. Of course, it's another case, another some sort of showcasing of the ruling, just getting involved into the sovereignty-centered disputes, because based on the Chinese claim, U-shaped line served as some sort of central piece to legitimate the Chinese sovereignty claim over maritime features. So U-shaped line framed water area is shattered with different maritime features. The Beijing say, why such a maritime features belong to China? Because U-shaped line is the first one for China to initiate the sovereign claim back to in 1948. So justification of U-shaped line is definitely equal to some sort of such a sovereign claim of the maritime features. It's not just a very logic and very conceivable in the Chinese case, but it's also very, I think, elaborated in international context. Then now the ruling say no. U-shaped line is totally invalid. What does it mean? That means it's a delegitimate the China's sovereign claim in South China Sea. So we totally disagree.
Are you concerned that this ruling will increase the China threat theory that circulates in many countries in the world?
Of course. China's rejection to the ruling will be broadly perceived as some sort of Chinese bizarre behavior, because we don't want to recognize the international norm. So then in the generalized sense of international community, not recognizing international law is definitely mean you're not a good guy. But the problem is, we couldn't be that kind of simple. Then we will see international law is very, very important. But the problem is international law usually is a very interesting instrument in international context. No power, no state could just very, very simply believe law could truly supersede any real and pragmatic thinking on how the sovereign state could real cooperation or work together.
China has a massive stake in upholding the international order and strengthening the UN. Of all the major economies, China is most dependent on global trade, for which maritime stability is essential. That said, after a century of national humiliation, when China's sovereignty was trampled repeatedly and wantonly, China today is not about to compromise its national rights. President Xi Jinping spoke for the Chinese people when he said, "No foreign country should expect us to swallow the bitter pill of harm to our national sovereignty." While the Tribunal award does not determine sovereignty, because the law of the sea does not rule on sovereignty, it does deny legal basis for China to claim historic rights, and it does adjudicate territorial and economic zones from maritime features such as islands, rocks, and reefs. China asserts that this is a distinction without a difference, in that sovereignty is indeed the underlying issue, and therefore the tribunal does not have jurisdiction. And China is not about to bargain away its sovereignty. No party benefits from blow-up. In a globalized world, China and the U.S. will flourish together or flounder together. A temporary solution is simply to maintain the status quo. Let time work its magic. Whether the parties can do so is the challenge. That's closer to China.